Good day. Welcome. I'm Michelle D. Daroy of BSBA 3A. We're the first group to report in our e-report relative to our subject, Partnership and Corporation Law, about the Republic Act number 11232, otherwise also known as Revised Corporation Code of the Republic of the Philippines. We were assigned to tackle about the titles 2, 3, and 4 for the following salient amendments to the Corporation Code of the Philippines. To start with, let me read title number 2, Incorporation and Organization of Private Corporation, Section 10, Number and Qualification of Incorporators. In the old Corporation Code stated here that any number of natural person not less than 5 but not more than 15, all of legal age and a majority of whom are residents of the Philippines, may form a private corporation for any lawful purpose or purposes. In the Revised Corporation Code, any person, partnership, association, or corporation, singly or jointly with others, provided that natural person who are licensed to practice a profession, and partnership association organized for the purpose of practicing a profession, shall not be allowed to organize as a corporation unless otherwise provided under special laws. Incorporators who are natural persons must be of legal age. The brief summary of change this Corporation Code stated here that juridical persons are now qualified to be incorporators, and a stockholder is now allowed to become a sole incorporator, as what they called a one-person corporation. There is no longer a minimum number of incorporators required. Even residency in the Philippines is no longer required for incorporation. A natural person licensed to practice a profession and partnership organized for the purpose of practicing a profession are disqualified from becoming incorporators except under special laws. In Section 11, corporate term in the old Corporation Code, a corporation shall exist for a period not exceeding 50 years from the date of incorporation unless sooner dissolved or unless said period is extended. The corporate term, as originally stated in the Articles of Incorporation, may be extended for periods not exceeding 50 years in any single instance by an amendment of the Articles of Incorporation, in accordance with this code, provided that no extension can be made earlier than 5 years. Yes, prior to the original or subsequent expiry date, unless there are justifiable reason for an earlier extension as may be determined by the Securities and Exchange Commission. Whereas in the Revised Corporation Code, perpetual existence unless its Articles of Incorporation provided otherwise, corporation with certificates or incorporation issued prior to the effectivity of this code, and which continue to exist, shall have perpetual existence, unless the corporation, upon a vote of its stockholders representing a majority of its outstanding capital stock, notifies the Commission that it elects to retain its specific corporate term pursuant to its Articles of Incorporation, provided that any change in the corporate term under this section is without prejudice to the appraisal right of dissenting stockholders in accordance with the provision of this code. A corporate term for a specific period may be extended or shortened by amending the Articles of Incorporation, provided that no extension may be made earlier than 3 years prior to the original or subsequent expiry dates, unless there are justifiable reason for an earlier extension as may be determined by the Commission, provided further that such extension of the corporate term shall take effect only on the day following the original or subsequent expiry date. As we have mentioned earlier from the old Corporation Code, that no extension can be made earlier than 5 years prior to the original subsequent expiry date, whereas to the new revised corporation code that there will be no extension made earlier than 3 years. So the changes have made in here, corporation shall have perpetual existence unless otherwise provided in the respective articles of incorporation. Those which have specific periods of existence may opt to shorten or extend their corporate terms, subject to certain limitations. Corporation with expired terms may now be revived. In Section 12, minimum capital stock required of stocks corporations. In Old Corporation Code, stated here that stock corporation incorporated under this code shall not be required to have any minimum authorized capital stock except as otherwise specifically provided for by special law and subject to the provision of the following section. The revised corporation code, corporation shall not be required to have a minimum capital stock except as otherwise specifically provided by special law. The brief summarization change of this Section 12 is that there is no longer a minimum amount prescribed for both subscribed and paid up capital stock. In Section 13, amount of capital stock to be subscribed and paid for purposes of incorporation. In Old Corporation Code, at least 25% of the authorized capital stock, as stated in the Articles of Incorporation, must be subscribed at the time of incorporation. And at least 25% of the total subscription must be paid upon subscription. The balance to be payable on a date or date fixed in the contract of subscription without need of call, or in the absence of a fixed date or dates upon call for payment by the Board of Directors, provided, however, that in no case shall be paid up capital be less than 5,000 pesos. In Revised Corporation Code, let us just go back and read the article description in the Section 12, which stated there that there is no amount required no more. The brief summary change is that only Section 12 of the RCC supersedes Section 13 of the Corporation Code. In Section 14, contains of the Articles of Incorporation. In the Old Corporation Code, all corporation organized under this code shall file with the Securities and Exchange Commission Articles of Incorporation in any of the official languages, duly signed and acknowledged by all of the incorporators, containing substantially the following matters, except as otherwise prescribed by this code or by special law. There's a table here that I have made that shows the different changes from the Old Corporation Code to the new Revised Corporation Code. And the Securities and Exchange Commission shall not accept the Articles of Incorporation of any stock corporation unless accompanied by the sworn statement of the treasurer elected by the subscribers showing that at least 25% of the authorized capital stock of the corporation has been subscribed. At least 25% of the total subscription has been fully paid to him in actual cash or in property, the fair valuation of which is equal to at least 25% of the said subscription, such paid up capital being not less than 5,000 pesos. In new Revised Corporation Code, all corporations shall file with the Commission Articles of Incorporation in any of the official languages duly signed and acknowledged or authenticated in such form and manner as may be allowed by the Commission. An arbitration agreement may be provided in the Articles of Incorporation pursuant to Section 181 of this Code. The Articles of Incorporation and application for the amendments thereto may be filed with the Commission in the form of an electronic document in accordance with the Commission's rules and regulation on electric filing. Section 181, Arbitration for Corporations. An arbitration agreement may be provided in the Articles of Incorporation or bylaws of an unlisted corporation when such an agreement is in place. Disputes between the corporation, its stockholders or members which arise from the implementation of the Articles of Incorporation or bylaws or from intra-corporate relations shall be referred or arbitration. So a dispute shall be non-arbitrable when it involves criminal offenses and interests of the third parties. The arbitration agreement shall be binding on the corporation, its directors, trustees, officers, and executives or manager as mandated by the Section 181 of the Revised Corporation Code of the Philippines, which I only tackle this Section 181 because it's just stated here in the Section 14. So next, the brief summary change of the Section 14. The Articles of Incorporation may now be authenticated, subject to the discretion of the SEC. There is now a presumption that all corporation exists in perpetuity unless it elects a specific term of existence. Moreover, the Articles of Incorporation may now contain an arbitration agreement subject to the rules set forth in the RCC. More importantly, corporation may now apply for the initial filing and amendment of their Articles of Incorporation electronic, which I have mentioned earlier. Subject to the rules of the SEC on electronic filing, this new section no longer requires the treasurer's certification that the capital stock has been subscribed for at least 25% and paid up for at least 25%. In Section 15, Forms of Articles of Corporation. Unless otherwise prescribed by special law, Articles of Incorporation of all domestic corporation shall comply substantially with the following form. Originally, in the link that have emailed to us, there's this form that the corporate or the trustees that are going to fill up the form. Still, they remain as is to fill up forms in old core code and in the revised code corporation. The same procedure that they are going to fill up the form. So the changes made is that the prescribed format of the Articles of Incorporation has been revised, implying the following. 1. Corporation have the option to elect perpetual existence or limit their existence to a term. Number 2, the capital stock does not require a minimum subscription and paid up amount. An existing corporation's prior right over its name shall be safeguarded by the inclusion of a mandatory undertaking in the new format. A treasurer's affidavit is no longer required. So as what I have mentioned earlier, that there are no longer requires the secretary's or the treasurer's certification that has been subscribed. In Section 16, Amendment of Articles of Corporation. In the old Corporation Code, Batas Pambansang Bilang 68, and in new revised Corporation of Code Republic Act number 11232, in Section 16 has the same conduct to follow. Nothing really numerous changes as what I have read and understand, but still there is a requirement to follow, and as stated in here. In Section 16, grounds when Articles of Incorporation or amendment may be disapproved. The Commission may disapprove the Articles of Incorporation or any amendment thereto if the same is not compliant with the requirements of this code, provided that the Commission shall give the incorporators, directors, trustees, or officers a reasonable time for receipt of the disapproval within which to modify the objectionable portions of the articles or amendment. The following are grounds for such disapproval. A. The articles of incorporation or any amendment thereto is not substantially in accordance with the form prescribed herein. B. The purpose or purposes of the corporation are patently unconstitutional, illegal, immoral, or contrary to the government rules and regulation. C. The certification concerning the amount of capital stock subscribed and or paid is false. And D. The required percentage of Filipino ownership of the capital stock under existing laws or the Constitution has been complied with. No articles of incorporation or amendments to articles of incorporation of banks, banking, and quasi-banking institution, insurance and trust companies, pawn shops, and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency to the effect that such articles or amendments in accordance with the law.
Section 17. Grounds when articles of incorporation or amendment may be rejected or disapproved. So there are 4 grounds for such rejection or disapproval. First is that the articles of any corporation's amendment thereto is not substantially in accordance with the form prescribed herein. Next, that the purpose or purposes of the corporation are patently unconstitutional, illegal, immoral, or contrary to the government rules and regulations. Next, that the treasurer's affidavit concerning the amount of capital stocks prescribed or are paid is false. Next, that the percentage of ownership of the capital stock to be owned by the citizens of the Philippines has not been compiled with as required by existing laws of our Constitution. So the Securities and Exchange Commission may reject these articles of incorporation or disapprove any amendment thereto if the same is not in compliance with the requirement of this code. So provided that the Commission shall give the incorporators a reasonable time within which to correct or modify the objectionable portions of the articles or amendment. So per end, companies or pawn shops are now required to submit their applications to amend their articles of incorporation to their respective regulators or endorsement to the SEC. Section 18. Corporate name. So no corporate name may be allowed by the Securities and Exchange Commission if the proposed name is identical or deceptively or confusingly similar to the other of any existing corporation or to any other name already protected by the law or is patently deceptive. So confusing or contrary to the existing laws. When an exchange in a corporate name is approved, the Commission shall issue an amended certificate of incorporation under the amended name. So all in all, the standard of determining whether a new corporation's name is valid or not is distinguishability from the names of existing corporations. So the Securities Exchange Commission power to regulate corporations' name has been expanded as it follows. First is to may summarily order new corporation to cease and desist the use of name. Next is may hold directors, officers in contempt or administratively, civilly, criminal liable for use of a name that is not distinguishable. Section 19. Commandments of a corporate existence. A private corporation formed or organized under this code commences to have corporate existence and juridical personality and is deemed incorporated from the date of Securities and Exchange Commission's issues a certificate of incorporation under its official seal, and thereupon the incorporators, stockholders, members, and their successors shall constitute a body politic and corporate under the name stated in the Articles of Incorporation for the period of time mentioned therein, unless said period is extended or the corporation is sooner dissolved in accordance with the law. So, All in all, the existence of new corporation is now subject to the following stages. So there are stages that the corporations existed. First is the verification with the SEC of the corporate name. The second is the registration of the name of the SEC of the articles of the incorporation and bylaws issuance by the SEC of the corporation. The date shall determine when a corporation commences its corporate existence and juridical personality. Section 20. De facto corporations. The due incorporation of any corporation claiming in good faith to be a corporation under this code, and it is the right to exercise corporate powers, shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a qua or quo-warranty proceeding. Section 21. Corporation by estoppel. All persons who assume to act as a corporation, knowing it to be without authority to do so, shall be liable as a general partners for all debts, liabilities, and damages incurred as arising a result thereof. So provided, however, that when any ostensible corporation is sued on any transaction entered by it is a corporation, or on any tort committed by it is such, it shall not be allowed to use as a defense its lack of corporate personality. On who assumes an obligations to an ostensible corporation as such cannot resist performance thereof on the ground that there was in fact no corporation. Section 22. Effects on non-use of corporate charter and continuous in operation of a corporation. If a corporation does not formally organize and commence the transaction of its businesses or the construction of its works within 2 years from the date of its incorporation, its corporate powers cease and the corporation shall be deemed disapproved or dissolved. However, if a corporation has commenced the transaction of its businesses but subsequently become continuously inoperate for the period of at least 5 years, the same shall be ground for the suspension or revocation of its corporate franchise or certificate of incorporation. So, this provision shall not apply if the failure to organize, commence the transaction of its businesses or the construction of its works or to continuously operate is due to the causes beyond the control of the corporation as may be determined by the Securities and Exchange Commission. So all in all, non-use of corporate charter must now be within a period of 5 years in order that the certificate of incorporation be deemed revoked. So this concept of delinquent status is also introduced, which shall be the status of corporations which have become inoperative for at least 5 consecutive years. Such status shall be lifted when corporations resume operation within 2 years. Otherwise, it shall be a cause for revocation of a certificate of incorporation. So regulatory agencies will be notified before any action can be taken of these corporations.
Title 3, Board of Directors, Trustees, and Officers. Section 23. The Board of Directors or Trustees, unless otherwise provided in this code, the corporate powers of all corporations formed under this code shall be exercised, all business conducted and all property of such corporations controlled and held by the Board of Directors or Trustees to be elected from among the holders of stocks, or where there is no stock for among the members of the corporation, who shall hold office for 1 year until their successors are elected and qualified. Every director must own at least one share of the capital stock of the corporation of which he is a director. which share shall stand in his name of the books of the corporation. Any directors who ceases to be the owner of at least one share of the capital stock of the corporation of which he is the director shall thereby cease to be the director. Trustees of non-stock corporation must be members thereof. A majority of the directors or trustees of all corporation organized under the code must be residents of the Philippines. Term of the office of trustees are included in this section. Corporations vested with public interests are now required to elect independent directors at a number constituting at least 20% of their board of directors. Independent directors are defined in this section as well. Section 24. Elections of directors or trustees. At all elections of directors or trustees, there must be present, either in person or by representative, authorized to act by written proxy, the owner of majority of outstanding capital stock. There be no capital stock, a majority of members entitled to vote. Any meeting of the stockholders or members called for an election may adjourn from day to day or from time to time, not sine die, or definitely if, for any reason, no election is held, or if they're not present or represented by proxy at the meeting, the owners of the majority of the outstanding capital stock, or if there be no capital stock, a majority of the member entitled to vote. Stockholders, when authorized in the bylaws or the board of directors, may now cast their votes in absentia and shall be deemed present for purposes of quorum. There is now an alternative method of calling an election, whether a quorum is not determined. Directors and trustees shall be guided not only by the bylaws but also by the rules of good corporate governance. Section 25. Corporate Officers Quorum. Immediately after their election, the directors of a corporation must formally organize by the election of a president, who shall be a director, a treasurer who may or may not be a director, a secretary who shall be a resident and citizen of the Philippines, and such as officers as may be provided for in the bylaws. Concurrently holding the position of president and secretary or president or treasurer is allowed only in instances provided under the code. Section 26. Report of election of directors, trustees, and officers. Within 30 days of the election of the directors, trustees, and officers of a corporation, the secretary or any other officer of the corporation shall submit to the Securities and Exchange Commission the names, nationalities, and residencies of the directors, trustees, and officers elected. Non-holding of election must now be reported to the SEC within 30 days from the date of the scheduled election, and a new schedule must be set. Any stockholder, member, directors, or trustee may apply to the SEC for the elections to be similarly held whenever a scheduled election was not conducted or no new schedule was designated. Section 27. Disqualification of directors, trustees, or officers. No person convicted by final judgment of an offense punishable by imprisonment for a period exceeding 6 years, or a violation of this code committed within 5 years prior to the date of his election or appointment, shall qualify as a director, trustees, or officers of any corporation. The list of disqualification of directors, trustees, officers has now been expanded to include the following: 1. Conviction by final judgment for violating the SRC. 2. Administrative liability for commission of fraudulent acts. Section 28. Removal of directors or trustees. Any director or trustee of a corporation may be removed from office by a vote of a stockholders holding or representing at least 2/3 of the outstanding capital stock, or if the corporation be a non-stock corporation, by a vote of at least 2/3 of the members entitled to vote. The SEC is now vested with the power to remove, motu proprio, or upon verified complaint and after due hearing, a director trustee without prejudice to such other sanctions that may be imposed. Section 29. Vacancies in the office of director or trustee. Any vacancy occurring in the board of director or trustees other than by removal by the stockholders or members or by expiration of term may be filed by the vote of at least of the majority of the remaining directors or trustees, still constituting a quorum. Otherwise, said vacancies must be filed by the stockholders in a regular or special meeting called for that purpose. A director or trustee so elected to file a vacancy shall be elected only or an expired term of his predecessor in office. The rules on filing the vacancies in the board of directors, trustees, shall now depend on the cause of the vacancy as follows. 1. If the vacancy is due to term expiration, election must be held no later than the day of the such expiration. 2. If due to removal, election may be held on the same day, provided that it is mentioned in the agenda. 3. In all other cases, election must be held within 45 days from the fact. The director who shall be elected under such circumstances shall be referred to as a replacement director. The concept of a temporary director is introduced whereby an officer may temporarily fill the vacancy by unanimous vote of the board on cases requiring emergency actions.
Section 30. Compensation of directors. In the absence of any provision in the bylaws fixing their compensation, the director shall not receive any compensation as such director, except for reasonable pay deems provided. However, that any such compensation other than per diems may be granted to directors by the vote of the stockholders representing at least the majority of the stock of the outstanding capital stock at a regular or special stockholders meeting. In no case shall the total yearly compensation of directors as such director exceed 10% of the net income before income tax of the corporation during the preceding year. Director or trustee are now explicitly prohibited from determining their own per diems. Corporation vested with public interest are now required such to submit the stockholders and the commission in exchange commission an annual report of the total compensation of each director or trustee. Section 31. Liability of directors, trustee or officer. Director or trustee who willfully and knowingly vote for on assent to patiently unlawful acts of the corporation who are guilty of gross negligence or bad faith in directing the affairs of the corporation or acquired any personal or pecuniary interest in the conflict with their duty as the director or trustee shall be liable jointly and severally for all damages resulting therefrom suffered by the corporation, its stockholders or members and other person. When a director or trustee or officer attempts to require or acquires in violation of his duty any interest adverse to the corporation and respect of any matters which has been reposed in him in confidence, as to which equity imposed a liability, disability upon him to deal in his own behalf. He shall be liable as a trustee for the corporation and must account for the profits which otherwise would have accrued to the corporation. Section 32. Dealing of directors, trustee, or officers with the corporation. A contract of the corporation with one or more of its director or trustee or officer is voidable at the option of such corporation unless the following conditions are present. Number 1. That the presence of such director or trustee in the board meeting which the contract has approved was not necessary to constitute a quorum for such meeting. Number 2. That the vote of such director or trustee was nor necessary for the approval of the contract. Number 3. That the contract is fair and reasonable under the circumstances. And number 4. That in case of an officer, the contract has been previously authorized by the board of directors. When any of these two conditions set forth in the preceding paragraph is absent, in the case of a contract with a director or trustee, such contract may be ratified by the vote of the stockholders representing at least 2/3 of the outstanding capital stock or of at least 2/3 of the members in a meeting called for the purpose, provided that full disclosure of the adverse interests of the director or trustee involved is made at such meeting, provided however that the contract is fair and reasonable under the circumstances. Section 33. Contracts between corporation with interlocking directors, except in case of fraud, and provided a contract is fair and reasonable under the circumstances. A contract between two or more corporations having interlocking directors shall not be invalidated on the ground alone, provided that if the interest of the interlocking director is one corporation is substantial and his interest in the other corporation or corporation is nearly nominal, he shall be subject to the provision of the preceding section insofar as the latter corporation or corporation are concerned. Stockholders exceeding 20% of the outstanding capital stock shall be considered substantial for purpose of interlocking director. Section 34. Disloyalty of a director. Where a director by virtue of his office acquires for him a business opportunity which should belong to the corporation, thereby obtaining profits to the prejudice of such corporation, he must account to the latter for all such profits by refunding the same, unless his act has been ratified by a vote of the stockholders owning or representing at least 2/3 of the outstanding capital stock. The provisions shall be applicable notwithstanding the fact that the director raised his own funds in the venture. The changes constitute rewarding or certain sentences, but the concept is similar. Section 35. Executive Committee. By law of the corporation, may create an executive committee composed of not less than 3 members of the board to be appointed by the board. Said committee may act by majority vote of all his members on such specific matters within the competence of the board as may be delegated to it in the bylaws or on the majority vote of the board, except with respect to number 1, approval of any action for which stockholders' approval is also required. Number 2, by filing of vacancies in the board. Number 3, the amendment or repeal of bylaws or the adoption of new bylaws. Number 4, the amendment or repeal of any resolution of the board which by its express term is not so amendable or repeatable. And number 5, a distribution of cash dividends to the stockholders. Board committee may now be special and temporarily subject to the determination of the board of directors of the committee members' term, compensation, power, and responsibility.
Title 4, Powers of Corporation. Section 36, Corporate Powers and Capacity. Every corporation incorporated under this code has the power and capacity, number 1, to sue and to be sued, and its corporate name. So meaning, kaya niyang maghain ng kaso at the same time, pwede rin siyang kasuhan yung mismong corporation. Number 2, of succession by its corporate name for the period of time stated in the Articles of Incorporation and the Certificate of Incorporation. Dati, 50 years lang ngayon, and Revised Corporation Code, perpetual existent na po. Number 3, to adopt and use a corporate sale. Number 4, to amend its Articles of Incorporation in accordance with the provisions of this code. Number 5, to adopt by laws not contrary to law, morals, or public policy, and to amend or repeal the same in accordance with this code. Number 6, in case of stock corporations, to issue or sell stocks to subscribers and to sell stocks to subscribers and to sell treasury stocks in accordance with the provisions of this code, and to admit members to the corporation if it be a non-stock corporation. Number 7, to purchase, receive, take or grant, hold, convey, sell, lest, pledge, mortgage, and otherwise deal with such real and personal property, including securities and bonds of other corporations, as the transaction of the lawful business of the corporation may reasonably and necessarily require, subject to the limitations prescribed by law and the Constitution. Number 8, to enter into merger or consolidation with other corporation as the provided in this code. So, the sake of opinion, by the default of general rule, hindi pwedeng mag-enter into partnership nitong corporation. So this is the opinion of old code pero dahil may revised corporation code na this time, shall enter partnership no longer seek of opinion na po. Number 9, to make reasonable donations, including those for the public welfare or for hospital, charitable, cultural, scientific, civic, or similar purposes, provided that no corporation, domestic or foreign, shall give donations in aid of any political party or candidate or for purposes of partisan political activity. Number 10, to establish pension, retirement, and other plans for the benefit of its directors, trustees, officers, and employees. 11, to exercise such other powers as may be essential or necessary to carry out its purpose or purposes as stated in the Article of Incorporation. Section 37. Power to extend or shorten corporate term. A private corporation may extend or shorten its term as stated in the Article of Incorporation when approved by a majority vote of the Board of Directors or Trustees and ratify a meeting by the stockholders representing at least 2/3 of the outstanding capital stock or by at least 2/3 of the members in case of non-stock corporations. Written notice of the proposed action and of the time and place of the meeting shall be addressed to each stockholder or member at his place of residence as shown on the book of the corporation, disposited to the addressee and the post of office with postage prepaid or served personally provided, and in case of extension of corporate term, any descending stockholder may exercise his appraisal right under the conditions provided in this code. Section is applicable lang ito pag naglagay ng specific term ang corporation dahil if hindi tayo naglagay ng specific term, so ano ba ang at default? So in the perpetuity, meaning hindi ma-extend or maso-shorten dahil infinity nga, pero kapag naglagay ng specific term, for example, na inadapt pa rin natin yung dating corporation code na 50 years, so it happened na it could be extended or shortened. So in extending shortened corporation term that stated that in section 37, so we need approval and majority vote of director and trustees. Section 38, power to increase or decrease capital stock, incur, create, or increase bonded indebtedness. So no corporation shall increase or decrease its capital stock or incur, create, or increase any bonded indebtedness unless approved by a majority vote of the Board of Directors and at a stockholders meeting duly called for the purpose. 2/3 of the outstanding capital stock shall favor the increase or diminution of the capital stock or incurring, creating, or increasing of any bonded indebtedness. Written notice of the proposed increase or diminution of the capital stock or of the incurring, creating, or increasing of any bonded indebtedness, and of the time and place of the stockholders meeting at which the proposed increase or diminution of the capital stock or the incurring of increasing of any bonded indebtedness is to be considered, must be addressed to each stockholder at his place of residence as shown in the books of the corporation and deposited of the addressee in the post office with postage, prepaid, or served personally. Kung mapapansin natin na almost lahat dito sa specific power, ang voting requirement is majority of 2/3. For example, may six person, so dapat you could get 4 out of the 6 kay 2/3 man. And remember, at the application that made of 6 months from the date of approval of the board of director and stockholders. Then before, since hindi uso ang electronic, dinid written notice talaga, and nowadays uso ng electronic data. So by electronic data, pwede na siya i-send yung pinag-uusapan nila or yung meeting nila, but in accordance with the rules and regulation of the commission and use of electronic data messages, so may batas pa rin. Section 39, Power to deny preemptive right. All stockholders of stock corporation shall enjoy preemptive right to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings, unless such right is denied by the Articles of Incorporation or an amendment thereto, provided that such preemptive right shall not extend to share to be issued in compliance with laws requiring stock offering or minimum stock ownership by the public, or to shares to be issued in good faith with approval of the stockholders representing 2/3 of the outstanding capital stock in exchange for property needed for corporate purposes or in payment of the previously contracted debt. Preemptive, it is preferential right of the shareholder to subscribe to all issues or disposition of shares of any class in proportion to their respective shareholdings. Ito yung right mo para hindi ma-dissolve yung ownership percentage mo. For example, sa isang corporation ay mayroon tayong 100 stock. Let's say, sa out of 100 stock, you are own 20 stock for example. So, you have the significant influence. Meron kang 20 stock out of that 100 stock. And let's say, supposedly, subscribe doon sa 20%, para ang mangyayari, ikaw ang makakuha ng 2 stock. 20 stock before an additional of 2 stock at total 22 stock. So, 22 divided by 110, which is 100 stock before an additional of 10 stock. Newly issued stock equals 20%. So, it's same before na 20 divided 100 as 20%. So, hindi na bago ang percentage mo even nagtaas yung stock. Section 40, Sale or other disposition of assets. Subject to the provision of existing laws on illegal combinations and monopolies, a corporation may, by a majority vote of its board of directors or trustees, sell, less in exchange, mortgage, pledge, or otherwise dispose of all or substantially all of its property and assets, including its goodwill, upon such term and conditions and for such consideration, which may be money, stock, bonds, or other instrument for the payment of money or other property or consideration, as its board of directors or trustees may deem expedient when authorized with the vote of stockholders representing at least 2/3 of the outstanding capital stock, or in case of non-stock corporation, by the vote of at least 2/3 of the members and stockholders or members meeting duly called for the purpose. Written notice of the proposed action and of the time and place of the meeting shall be addressed to each stockholder or member at his place of residence as shown on the books of the corporation and deposited of the addressee and the post office with postage prepaid or served personally, provided that any dissenting stockholder may exercise his appraisal right under the conditions provided in this code. A sale or other disposition shall be deemed to cover substantially or the corporate property and assets if thereby the corporation will be rendered incapable of continuing the business or accomplishing the purpose for which it was incorporated.
Section 41. The power to acquire on share as stock of corporation shall have the power to purchase or acquire its own share for legitimate corporate purpose or purpose include but not limited to the following case, provided a following case that corporation has been unrestricted retained earning in its book to cover to share to purchase or acquired. Number 1. To eliminate fractional share arising out of stock dividends to collection or compromise or indebtedness to corporation arising out of unpaid subscription in a delinquency sale and to the purchase delinquent share sold during said sale and to pay desisting or withdrawing to a stockholder entitled to payment for their share under provision of this. Section 42. The power to invest in corporate funds in another corporation, business or for any other purpose. Subject to provision of this code, a private corporation may invest its fund in any other corporation or business for purpose other than the primary purpose for which it's organized when approved by the majority of the board of directors or trustees and ratified by the stockholder, presenting at the least two-thirds of the outstanding capital stock, or be the less of two-thirds of members in case of stock corporation. At a stockholder or member meeting due called for purpose, writing notice of the time, place of meeting shall be addressed to each stockholder. Member at his place of corporation disappointment address in post of office with poster prepaid or served personally, provided on desisting stockholder shall be appraisal of provided in code, provided however that where investment by the corporation responsibly necessary accomplish its primary purpose as stated in the article of incorporation, the approval of the stockholder or member shall be necessary. Section 43. The power to declare dividends. The board of directors stock corporation may declare dividends out of the unrestricted retained earning which shall be payable in cash in property of stockholder and basis of outstanding stockholder held by them, provided that any cash dividends due on liquid stock shall be first applied by unpaid balance on the subscription plus cost expenses of stock. Dividends shall be withheld from the delinquent stockholder until his unpaid subscription fully paid, provided future that stock dividend shall be issued without the approval stockholder representing not be less than third of their outstanding capital. At the regular special meeting duly called for purpose and stock corporation are be prohibited vibrating surplus profit excesses of the 100% their paid capital stock, except when justified by expansion project of program approved by the board of directors when the corporation is prohibited under the loan agreement. When financial situation or creator with local or foreign declare dividends with his consent as concern has yet been secured, or when be clearly showed that such retention of necessary under special circumstances of obtaining corporation such be there is need for special reserve probable contingencies. Section 44. Power to enter into management contract to no corporation shall be include a management contract with another corporation, unless contract which shall have been approved by the board of directors and stockholder owning at the least of majority of the outstanding capital. Stockholder or by less of majority of the members in the case of stock corporation of both the managing and managed corporation at the meeting duly purpose provided whereas stockholder or stockholder representing same interest of both the managing of and the managing corporation own the control more than third of the total outstanding stock entitled the vote at the managing corporation, or where majority of the members of the board managed corporation then be managed contract must approved by the stockholder of the managed corporation owning at least 2/3 of the total outstanding capital entitled to vote, or by at the least 2/3 of the members. In case non-stock corporation, no managing contract shall be entered into the period longer 5 years for any one term. Section 45 Ultra Buyers Act of Corporation. No corporation under this code shall be purposes or exercises any corporate powers expect thus confirmed by this code or by article of incorporation and is in expect such as necessary or incidental of exercise the power so confirmed